NACDL is the association of the nation's criminal defense bar.
So NACDL asked me to speak, and I appreciate the all expenses paid trip from Miami to Miami Beach. Thank you very much. And they said, here is your topic, representing the hated client. And I said, shit, all of our clients are hated. What am I supposed to talk about? I talk about this guy? Talk about her? Talk about him? Talk about him. I'm not going to talk about this. Here's my summary of advice in representing the hated client. Thank you very much. End of topic. So I changed the topic to first-degree ethics, hot topics for criminal practitioners, and it's been kind of a quiet time to be a legal ethics practitioner, right? I mean, has anything been going on? Anything at all? I put this presentation together. It was done like weeks ago. And then came Tuesday. And I'm sitting out here, having some coffee. Like 9 people come up to me. Hey, I got a question. Are you going to talk about Michael Cohen? Are you going to talk about the tape? I mean, can I not talk about the tape? Isn't that what everybody wants to talk about? A lawyer taping his client. Did you all bring copies of your tapes? I've only been doing this 24 years. I've never, knowingly, maybe at a karaoke bar, taped a client. So everybody raise your hand if you have taped a conversation with a client. Thank you very much. So here's an example of a hot topic, communication. Forget about what I was going to talk about. We're going to talk about him. Or maybe we'll talk about privilege. Anybody talking about privilege? A lawyer tapes a client and then releases the tape. Now, we all understand as criminal practitioners and as lawyers that there is privilege and there's confidentiality. So when we talk about privilege, we got to talk about this guy. The other hot topic is confidentiality, because there are things that may not be privileged, but they may be confidential. So Michael Cohen secretly recorded the President of the United States in a conversation, and the question is, does that make him a bad lawyer? I mean, is that even a question? And then last night around 10 o'clock, I mean, I can't get out of my own way. Michael Cohen's willing to tell the special prosecutor that his client knew about this meeting at Trump Tower regarding this female spy that came to give them dirt on Hillary Clinton. And in response, this is my favorite, Lanny Davis, Michael Cohen's lawyer, had no comment. But he told CNN, I just want to read that sentence again. Lanny Davis, a lawyer for Cohen, had no comment. But he told CNN, I have to wonder why the Trump people would put that out. It was not from us. And in a brief moment, I'm not going to talk about my political bent, but in a brief moment where I agree with the President of the United States, I asked the same question. What type of lawyer would tape a client? I'm asking this question of practitioners, of you guys, of everybody, and I'm still trying to get an answer. And I found one. I found one answer. Going back to law school, Professor Ronald Sullivan, Harvard law professor, he says, to all my wonderful students, please never tape a client without a client's knowledge and consent. The lawyer's duty is to be partisan advocate on behalf of the client. If you feel the need to tape a client, the better approach is to get the fuck out of the case. And that's all I have to say about this topic, except we'll probably talk about it at some point later today. Let's talk about the grievance process. Let's talk about when you get a bar complaint, which is if you're a criminal defense lawyer and you have never gotten a bar complaint, you're not a criminal defense lawyer. And this is what it feels like. And this is how you react. And then this is always my favorite part. I get the call. Brian, I got a bar complaint. It's due in 15 days, which to all my clients means 15 seconds. And I called the bar. Let me explain something to you. The bar, I don't care where you live, is the government. Is the government. When you are under investigation, whether you did nothing wrong, which I know you did nothing wrong, you don't pick up the phone and call the government. And then you sit down and you start writing your response, which always starts with this. How dare you? How dare you darken my door with these allegations? I donate to the Red Cross. I represented this guy for less money than I should have. He still owes me money, so how could I have committed an ethical violation? And after 24 years, this is the advice I give all my clients when you get a bar complaint. Do nothing. Take a deep breath. Relax. You have time to respond. You're not going to lose your license today. Chill out. Look for the file. Put it together and determine what evidence you have to respond. And don't respond like this, because the bar doesn't care. They know, especially in today's day and age with the internet, they know your reputation. They know how awesome or unawesome you are, and they don't care. Once you file the response, it doesn't work like this. You get the bar complaint on Monday, you respond on Tuesday, and on Wednesday the bar issues you an apology. It doesn't work that way. This is the government, and the government doesn't move quickly, so you're going to wait for a response. And this is what the person reading your response is asking themselves. Did you violate one of the rules? That's it. Not anything about your character, about how much money you donated to this, about how long you've been practicing, which, by the way, is an aggravating circumstance. We'll talk about that later. That's all they want to know, just the facts. I get these summaries from my clients that are 13 pages, and I send them back to them, and I say, here is our page-and-a-half response to the bar. And they go, well, I paid you all this money, a page and a half. No, we're going to submit a tome to the bar with my resume and everything I've ever done in my... No, we're not. We're just going to address the allegations. These people who are reading these responses are reading 15 other responses in the same day. Now let's talk about fee disputes, near and dear to the criminal defense lawyer's heart, because you get that complaint, right? I paid this lawyer $5,000. He worked on my case for 7 months, and he did nothing. Nothing. The case got dismissed, but he did nothing. I wanted probation. I wound up having to do community service. I want all my money back, 100%. And then I get the call. How much money should I give this guy? No. We don't give money back because we have non-refundable retainers, which we'll talk about later. We don't do that unless we've really taken a large fee and we've really done nothing. But the bar has a policy, and I don't care where you live, and their policy is we don't get involved in fee disputes, which is not really true. They say we don't get involved in fee disputes if it's just I want my money back because I think I paid too much money. There has to be some ethical violation. So keep that in mind when you get that typical complaint about money, is to try to narrow it down to, is there really an allegation of a violation of one of the rules? Which, by the way, I recommend you read the rules occasionally. I know you read them when you took the bar. You may have looked at them in a panic-stricken moment like 5 years ago. I read them when I go to sleep, but you should read them occasionally just to get an understanding. And by the way, don't just read the rules, read the comments. Because what the comments do is explain how the rules are to be interpreted, and there's a lot of gems in there. So eventually you get your decision from the bar. Are they going to move forward? Are they going to close the case? What are they going to do? They may decide to send it to a committee to review your file and determine whether they're going to actually go and file formal charges. And I understand that every state is different, but most states kind of work this way. Again, if you have an opportunity to go before a bar committee and plead your case, it's not about how awesome you are. You know, we get emotional about these are assailing our character when we get a bar complaint, because it's always the guy we worked really hard for, right? It's always that guy. He filed a bar complaint? Or you should send me a bottle of wine, not a bar complaint. That's the way it always works. And by the way, this is 100% guarantee. The person who threatens you with a bar complaint never files one. I don't know why that's true. It just is. It's the person you never hear from. They're the ones that file the complaints. Be wary of them. And eventually, if the bar decides to proceed, then, you got to decide whether you're going to trial, resolving it, whatever. So let's talk about the top 3 subject of bar grievances. Number 1, communication. And I know, look, I was an assistant public defender, criminal defense lawyer. I now represent fucking lawyers, so I get it. They call, and they ask the same question. What's going on in my case? Dude, it's Monday at 9:45 a.m. I talked to you Friday at 3 o'clock. Trust me, from my side, from the prosecutor's side, from the judge, from the cops, there is nothing going on in your case right now. But the problem is when clients don't hear from you, they start thinking. And what do? They start talking to people, and they start getting opinions about how you should be handling the case. So you should have a system in your office to communicate with your clients. You should obviously communicate with them after court, especially in kinds of cases where maybe they don't have to go to certain hearings, and you should call them. I like to call my clients on Sundays because they never expect to hear from you on a Sunday, and they think it's like, wow, he's calling me on a Sunday. And they appreciate it. And by the way, Sundays are great because the phone's not ringing, you're not in the office, you're not being disturbed by other things going on. Weekends are much better times to communicate with your clients. If you're going to do phone, great time. Email, text, whatever way your client wants to communicate, you should be communicating with them more, because even if you're giving them bad news, what's going to happen when they file a complaint, and it's usually mom who files a complaint and says, he hasn't called my son, you got to have some records. And email, text, those are great records. If you're making phone calls on your cell phone, you have a log. But write this stuff down. I know we're criminal lawyers. We don't like to write stuff down. I get it. But you really need to do that. The second reason you are going to get a bar complaint is diligence. And the excuse I hear for diligence all the time is, I'm busy. I got a lot of cases. I didn't have time to show up to court. I didn't have time to file that motion. The guy paid me $500. What does he want? He wants me to work on his case? I mean, come on. None of those are obviously excuses for a lack of diligence. And I've seen, at least in the Florida bar where I practice, them taking more of an aggressive view of a lack of diligence. And the third, I have some bad news for you. Lawyers get arrested. And whether you practice ethics, criminal defense, probate, God forbid, family law, whatever you do, you should know your state bar rules regarding reporting criminal misconduct. The number one reason you should know this is because it's great cocktail party conversation, right? Because remember when you started out as a criminal lawyer, you would go to a cocktail party, and the question was, hey, let me ask you this, because I've heard different things. If I get pulled over for DUI, should I blow or should I refuse? And this is even a better conversation about talking to lawyers about reporting requirements. For example, in Florida, there is no reporting requirement if you get arrested for a misdemeanor, which is great because the calls I get are, hey, I got arrested for DUI, I bonded out, and I immediately picked up the phone and called the bar because I thought like I was doing myself a favor, which maybe you're doing yourself a favor, but there's no requirement. And as lawyers, we want to know what the rules say. Felonies in Florida have to be reported within 10 days of charges being filed, not the arrest. I had a lawyer arrested in New York, and I called about the reporting requirements, and that godforsaken state, there's no reporting requirement in New York. I was shocked. So learn the reporting requirements. They're going to be different, possibly, for misdemeanors which are kind of the bulk of the reasons a lawyer may get arrested: DUI, domestic violence, those kinds of things. But obviously, if you get arrested for a felony as a lawyer, you're not only facing a different kind of reporting requirement, but possible loss of your license temporarily or permanently. So let's talk about retainer agreements. Does your state require a retainer agreement? Different states have different requirements. Most states require one if you're charging a contingency fee, which is illegal in a criminal case. So, for example, in Florida, retainer agreements are not required unless you have certain language that the client needs to agree to. My response to whether your state requires them is that I don't care. Always have something in writing. I don't care if you do it on a cocktail napkin, because when that client complains about what you were supposed to be doing for the fee that they paid you, and you have nothing to say except, well, we had a conversation, I've known him for a long time, I think I sent him an email. No. Write it down. Have an agreement. I look at retainer agreements all the time, 10-page retainer agreement. I think my retainer agreement is like 5 pages with the signature line. Don't make it complicated. You're not talking to, other geniuses out there. You're talking to criminals. Make it simple. And these are words to live by in a retainer agreement. Non-refundable, if your state allows it. Earned upon receipt, if your state allows it. Trial not included. Retrial not included. And I know none of us have ever got caught in a situation where there's a retrial, the retainer agreement's kind of unclear, and we do the retrial for free. This is always a good one too, although it may not help you in federal court. Appeal not included. Most important 3 words in a retainer agreement: payment of fee. No. Scope of representation. In my retainer agreement, I have a paragraph that says, scope of representation, in which I explain 2 things: what I'm going to do and what I'm not going to do. And I'm telling you that that is the most important thing for me as an ethics practitioner when I'm trying to determine whether there's an issue as to what the client and the lawyer agreed to. Put that paragraph in your retainer agreement if it's not, and please, do not say that the scope of representation is State versus Jones and the case number. That's not a scope of representation. That's bullshit. You put in there that you are going to confer with counsel, research, attend hearings, do what's reasonable and necessary to represent the client up and through this portion of the case. If this happens, this is not included. If this happens, this is not included. And write it like you're writing to a 2-year-old. Make it very, very clear. Trust me. I've gone back on retainer agreements and been like, thank God that was in there, because this guy would have nailed me if it wasn't. Let's talk about withdrawing from a case. Some of you may have withdrawn from a case in your career. The question is, filing a motion to withdraw, is it sufficient if the client has hired new counsel? The problem in the criminal practice, there's a lot of sloppiness that goes on, and it's allowed by judges, and we kind of do it. Get a call, hey, I'm in the case now, I filed notice of appearance, you're not the lawyer anymore. Oh, okay, great. Well, you are the lawyer until the judge determines that you're not the lawyer anymore. So, and lawyers have been sanctioned for this. I'm not just talking about this because, I'm here talking. I'm talking about experiences that I've had where the bar has said, well, why didn't your client file a motion to withdraw? Yeah, the guy said he hired a new lawyer, but guess what? That lawyer went on a drug binge and never showed up, and the judge was wondering where you were. File a motion to withdraw, and here's the secret: get an order. Because filing it's not sufficient. We don't have self-executing motions, which hopefully I'll be able to get to. Payment plans. I get into more arguments with lawyers about this. I do not believe in payment plans. I'm sorry. I believe they're non-payment plans. If it's a $5,000 fee and it's $1,500 down and $500 a month, you just got a $1,500 fee. Maybe $2,000, maybe. But, that's the way it is. But if in your retainer agreement you say that if payments are not made, you're going to cease work, is that sufficient? No. File a motion to withdraw. Your fee is your problem. It's not the judge's problem. It's not the prosecutor's problem. And if you didn't make the proper agreement with your client, it's your problem. So you could say whatever you want. You can have that phone call, I'm not going to court tomorrow unless you come in here and pay that fee. Well, you better show up in court tomorrow. Client may not think you're showing up and may come at 6 o'clock at night and drop you off some money, but you can't do that. I say if necessary. Obviously, you may have a pre-indictment case. If you're not in court, all bets are off. You don't have to file anything. There's nothing to file. You can have whatever arrangement you want with your client, but make sure it's in writing. The client goes and complains to the bar's looking at the client, because you're the lawyer, you're smart, you're supposed to know all these things. The client doesn't know anything. That's how the bar looks at it. So make sure it's in writing, signed by the client. Talking to witnesses. Can you tell a witness not to talk to the other side? Who says yes, I can tell a witness not to talk to the other side? Thank you. Very proud to be a member of NACDL. I'm sorry, you raised your hand. Yes. So there's a rule on this, fairness to opposing party and counsel. You can't unlawfully obstruct another party's access to evidence. You can't tell a witness to refrain from voluntarily giving relevant information. And don't tell me that prosecutors do this. I've been a lawyer a long time. I get it. But we can't do it, okay? We can, as my friend said, explain to witnesses how it all works. Listen, I can't tell you not to talk to anybody. You're a witness for me in my case. I would appreciate that if anybody contacts you by phone, email, comes to your house, whatever, that before you talk to them, you let me know because I'd like to be present. That's not obstructing. A prosecutor may argue it's obstructing because the witness may say, well, Mr. Tannebaum said, I shouldn't talk to you without him, whatever. But you can tell a witness, if you get contacted, please let me know because I would like to be around for any of these conversations. This is becoming a big thing with email. Communication with judge or official. An official is anybody who works for the judge. Federal court, it's a courtroom deputy, secretary, bailiff, anybody who works for the judge. So, in a case, you cannot communicate as to the merits of the case with the judge or official unless you're in court, it's in writing, or orally upon notice to the other side. Now, here's what's happening, right? We all have friends in the court system, right? We're friends with the judge's secretary. We hate the judge, but we're friends with the judge's secretary. And we send the judge's secretary copies of things to send to the judge, which is fine, as long as, opposing counsel is CC'd on that email. But don't start talking about the merits of the case. I'm sending you this motion for bond because the prosecutor is intractable and will not agree to anything below $100,000, which is ridiculous for this case. If you look at the facts, this should be a $10,000 bond. Can you set this for hearing? You can't do that, okay, ex parte. Now, if you want to do that with the prosecutor on the email, that's fine. But I have seen cases where friendly lawyers and friendly court officials are communicating via email about the merits of the case. Don't do that. Don't do it by phone. Don't do it by email, because the bar, at least in my state, is starting to see these things. Let's go back to privilege. Are attorney's fees privileged? One of 400 people just said no, and you're all in agreement. Probably not. This is a case out of Florida. There's no attorney-client privilege. It kind of makes sense as to retainer agreements and billing information unless they reveal the mental impressions and opinions of counsel. Now, I'm not telling you to go back to your retainer agreements and billing statements and start scribbling kind of your thoughts about the case and strategy and things like that, but I'm just telling you that if that doesn't exist, those things may be discoverable. I learned this a long, long time ago when I was a young lawyer. I was representing a witness in a case. We went in to give a statement, and at the end of the statement, the prosecutor, and I think he was just doing this for fun, said, how much you pay Mr. Tannebaum? Oh, I object. And he's like, object to what? None of your business how much I'm getting paid. It's not privileged. I was like, really? So anyway, attorney-client privilege. Does it still apply if a bar complaint is filed? Here's a scenario. This client just filed a bar. Man, I want to tell the bar so many things, but I can't because it's privileged. It's not privileged. It's in the rules. It's in there twice. confidentiality of information, when a lawyer may reveal information to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. I know. The client didn't file the bar complaint, so I'm wrong. Mom filed the bar complaint. I don't have a controversy with my client. Mom came into court and started saying all this crap about me. My client's just sitting there quietly with handcuffs in the box. Well, if you scroll down to section 4, it says to respond to allegations in any proceeding concerning the lawyer's representation of the client. So there you go. Now here's a little caveat. Don't talk about stuff that's not relevant. If your client says, he never told me X, Y, Z, you can say, well, I did, and let me tell you about the conversation we had. Here's exactly how that conversation went. First of all, he confessed to the crime, blah, 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 blah. And then he told me he wasn't taking the plea to 6 years. So now he's saying I never conveyed that plea to him. Here's the email exchange between the two of us. What you don't want to do is tell the bar that your client was having an affair with, somebody. That kind of irrelevant, salacious stuff in terms of violating privilege is going to make the bar kind of look at you. So don't do that. Social media, some of you may have interacted with social media, Facebook, Twitter, Instagram. If you're a 12-year-old child, maybe you're posting pictures on Instagram. I'm just kidding. I know a lot of adults using Instagram now. I'm sorry. So this is, and I just say that because, I'm not on Instagram, so I'm projecting that to everybody. It's like not knowing how to play chess. I hate chess because I don't know how to play it. Anyway, so this is an opinion out of Florida about, and this is stuff we talk about in terms of social media taking it offline. Pre-litigation, you can have a client change privacy settings. Makes sense, right? Nobody's entitled to see your social media. You're not destroying it. You're not deleting it. You're just putting it on private. And, this happens when the girl comes in, she just committed DUI manslaughter, and she's got all these pictures of her drinking. What do? Put it all in private. Okay? If there's a rule regarding preservation of spoliation, make sure you review what that says, but nobody is entitled to view what you have put out there on social media. You can advise a client to remove information as long as it's not destroyed. This is after the client's arrested. Before the client's arrested, there's really nothing going on. There's no case proceeding. Maybe there's not even an investigation. You're going to get those kinds of questions. Well, what do I do with my Facebook, Twitter, LinkedIn, Instagram account? And again, like we were talking about choices, explain what the options are. It's just like what I do with the marijuana case. Mom comes in and she goes, I found marijuana in Johnny's room. Should I flush it down the toilet? Ma'am, I can't tell you to flush it down the toilet, but here's what I can tell you. If the cops come in your house and they find that marijuana, you could get arrested, Johnny could get arrested, anybody who's determined to have control can get arrested. So I'm just letting you know that if it's in the house, somebody can get arrested. Okay, so I should flush it down the toilet. Let's talk about this new thing, friending enemies. This is an article. You can find it on the internet by a friend of mine, Jennifer Ellis. Friending somebody on social media is considered contact. And now we're talking about contacting witnesses on the other side who may be represented by counsel. Okay? Attorneys should never seek to friend or obtain access to the account of an opposing party if that party is represented. Now, you can ask your friends if they're friends with other people on social media and what's going on over there, but if you make that direct contact, you could be subject to violating the rule regarding contacting somebody represented by counsel. And if you're seeking to friend a witness, you've got to make clear who you are. And I actually had a case like this where a guy who doesn't really practice law, but he is a lawyer and a member of the bar, went to meet with somebody and they started talking to him. They were represented by counsel, but didn't know he was a lawyer because he didn't identify himself as a lawyer. And, the bar was a little concerned about that. This includes your investigator, so let's not do the whole, what about my investigator? Your investigator is an agent of you. It's considered contact on behalf of you. Let's talk about the file. The precious file. Do I have to give back the file? The guy owes me money. He just fired me, and I've got his file. Do I have to turn over the file if I haven't been paid? See, I'm not a good lawyer in this case because I'm always like, are you a child? I mean, do you really want a motion filed and you go to court and the judge's like, Mr. Tannebaum, do you have the file? Yes. You know your client's set for trial in 2 weeks. I mean, will you give it back? No, Judge, he owes me $1,800. I'm ordering you to give back the file. I don't want to be there, and I don't want you to be there. So let's look at what the rules are. And this is in Florida, it may be different somewhere else, but this kind of makes sense. You have a retaining lien against the file if your client owes costs, because that's money out of pocket. And a retaining lien can be perfected in various ways. In Florida, you just stand on a rooftop and say, I have a retaining lien, and that's it. You can file one, but you don't have to. Some states require that you file a retaining lien, which is just filing a document saying, I retain the file based on this. But now we're talking about cost. Okay? Sorry, let me go back. A retaining lien does not require judicial action in Florida, just possession of the items. That's why it's called a retaining lien. Now, what about fees? Well, if you look at the rule 1.16, talking about protection of client's interests, says you must surrender papers and property to which the client is entitled. So they're entitled to their passport, their birth certificate, any original documents they gave you. Discovery, you can argue they can get it somewhere else. You can call me and go, can I charge him 25 cents a page for, do whatever you think is right. If you want to send the client a bill for $37 who may be filing a bar complaint against you, be my guest, okay? You can retain papers and other property relating to or belonging to the client to the extent permitted by law. Now, I know in Florida their position is, look, if the client owes you money, you can sue them. You have a remedy, so sue the client. But you can't keep the file. So let's talk about communication with people represented by counsel. You can't talk to them about the subject of the representation. You can talk to them about anything else. That's why we always get mad when prosecutors talk to our clients about other cases, and we're like, well, that's unethical. It's not. It's sleazy, but it's not unethical to do that. You cannot talk to somebody represented by counsel about the subject of the representation in which they are represented by counsel. You can talk to them about anything else. And this is the question I always get. Well, they initiated contact with me. The guy called me. He was pissed off with his lawyer, so he called me. But you're a lawyer. He doesn't go by the rules of professional responsibility. He's a client. You're the lawyer. You have to say, sir, I cannot talk to you. You're represented by counsel. You can call your friend and say, hey, Bill, can you represent this guy? I think he needs a new lawyer. But you cannot communicate with the guy, regardless. You have to know the person is represented, and it has to be actual knowledge, but you can't close your eyes. You can't say, well, I haven't seen anything in writing. If you know the guy's represented by counsel, don't play that game. Don't cross the line. Ex parte proceedings, if you're going to do them, you have to present all material facts known to the lawyer, whether or not the facts are adverse. And the issue with communicating an ex parte case is very much frowned upon, even in the most egregious situations. This was a fascinating article I read. This is a case where a prosecutor had ex parte communications with no notice to defense counsel. But the issue was that the prosecutor learned that witnesses were going to be killed. So the prosecutor said, well, I got to go tell the judge. I can't go tell a defense lawyer because it's his client who's involved, and he's got an obligation to go to his client, so I got to ex parte the judge. And so the prosecutor wanted an ex parte hearing, got recorded phone calls from the defendant about the defendant threatening witnesses, judges, counsel, criminal case. Bar counsel says, I don't know, and this is the crux here, I don't know of any rule or law that authorizes this, which means you're committing an ethical violation by doing it. So says that even though it's great concern that a lawyer would learn about this, you cannot have an ex parte conversation. You have to ask for a hearing with all parties present to discuss this matter. And I actually had this case in Florida with a lawyer who called me and said, this is going on. There's recorded telephone conversations. I need to go to the judge. And I said, you need to tell the prosecutor and bring them in. And it all got resolved. He withdrew from the case. This is a case in Florida where a case actually got dismissed because a prosecutor assumed there was a crime fraud exception, which had not been ruled upon by anybody except the prosecutor in its own mind, that there was a crime fraud exception of privilege, had 17 ex parte hearings with the judge, convinced the judge to turn over confidential information, and the appellate court upheld the entire dismissal of the criminal case just based on that. So bar counsel says the obvious, if you're ever in doubt, don't ex parte. Want to talk about a couple of cases to close this out. These are bar discipline cases that occurred in Florida, which encompass many things, and they're kind of interesting. So this is a case where a lawyer was hired to represent a client at a resentencing, got a hearing notice on March 19th for a hearing 10 days later, and filed a motion to continue notice of unavailability, saying that the notice was not reasonable, didn't have adequate time. And the lawyer said he was unavailable because he was busy filing or writing a petition for a writ of cert for another client. The court held in his bar case that the lawyer did not indicate in the motion whether the state agreed to the continuance, didn't send a copy to the judge, didn't set the motion for hearing. And on the day set for the hearing, the judge traveled to another circuit with his staff, and the lawyer did not show up. So everybody was kind of sitting there. Prosecutor, everybody was there. The family of the client was there. Talk about communication. So the judge had to reschedule the hearing for another date. The judge testified at this lawyer's bar hearing that he would have continued the case. And of course, the prosecutor jumped in and said, "Oh, me too. I had no problem with it. I would have agreed to it. No problem." So this is what I hear all the time from the old guard. I've been a lawyer 40 years in the bar, and I've never gotten a complaint. That's a problem, by the way. That's an aggravating circumstance under the rules that experience in the practice of law aggravates your sentence. That's why I'll take a 5-year lawyer all day. I can just go in and go, he's been a lawyer for 5 years. What, do you think he knows? I mean, he didn't know you can't take money out of the trust account. He's only been doing this for 3.5 years. But if you've been practicing more than 5 years, you're considered to have substantial experience in the practice of law. And that's what the referee found, and that he should have known that a motion to continue was not self-executing. And making things worse was that the lawyer did not call the judge after the hearing. He just didn't show up. He just filed it. But didn't ask for a hearing. So he files a motion says, "I'm not available. Here's a motion to continue. I guess somebody will get back to me." He never did anything. So instead of the lawyer calling the judge, he retained a lawyer. And the lawyer called the judge to inquire about the hearing. And I'm just picturing this in my mind, right? The JA answers the phone. "Hi, I'm a lawyer for the lawyer who didn't show up today," i.e. that we got a problem here. So he was found guilty of diligence, promptness, and the catch-all 4-8.4, which is, dishonesty, conduct prejudicial to the administration of justice, and the two aggravating factors were substantial experience and his refusal to acknowledge the wrongful nature of his misconduct. And so the court said that continuing court hearings results in undue hardship to the administration of justice. This is one of those general statements the Florida Supreme Court likes to make, like when the next few cases come to us, we're going to be looking at these continuing court hearing things. So the referee recommended a public reprimand, that the guy undergo an evaluation and go to law office management assistance to get his office in order and pay costs in the amount of $2,830. And what did the lawyer do? He appealed. That is the Florida Supreme Court. They are the final arbiter on all lawyer discipline. And the grounds were that the referee's recommendation wasn't supported because there was no evidence that the client suffered any harm. And the court agreed. And the reason was because the hearing was rescheduled and the client got a lesser sentence. So everybody's happy. And the lawyer showed evidence that the family was very happy with the lawyer's representation. But the court said that there is no requirement that a client suffer actual harm. And this is a big problem for me, because I argue this all the time, right? As criminal defense lawyers, we argue, nobody died. I mean, he threw a rock at his head. He'll be out of the hospital in 3 days. I mean, come on. Seriously, you've seen worse. And that's what this guy argued. No harm. Yeah, I didn't show up, whatever, but look, the client's happy. And the court said, as for substantial experience, that he should have known that these pleadings were not self-executing, requiring a ruling. The lawyer doubles down and says that the judge unilaterally scheduled the hearing. He didn't ask me if I was available. He didn't call me to see if it was convenient for me to be there. So, and that he provided insufficient notice, time to prepare. The referee found It is of no consequence. I just imagine this being read. It is of no consequence as to how the hearing was set, by whom, or at whose request. And the Supreme Court found that regardless of the lawyer's reasons for doing so, he may not choose to attend a hearing. So, what happened? The court agreed that a public reprimand was appropriate and a 10-day suspension. By the way, when you get suspended, you have to notify all your clients, your banking institutions, any judges that you have cases in front of. It gets published in various newspapers, and of course, in 2018, it goes on the internet. This is the last case I'm going to talk about. This case came out in January of this year. So in 2013, this lawyer opened a medical marijuana law practice. It's all the rage now, medical marijuana. He had no training in the area of medical marijuana. And 6 months later, he forms this Health Law Services and then incorporated Cannabinoid Therapy Institute. Very industrious lawyer. He hires this non-lawyer named Christopher Ralph. He's a self-professed expert in marijuana, medical marijuana. He becomes the director of the Cannabinoid Therapy Institute and the legal administrator and consultant for the Health Law Service. Clients are charged $799 to come in for a doctor's visit, and if the doctor finds medical necessity, he gives what is created by the lawyer to be an official legal certification, saying that this is a marijuana prescription coming from a lawyer's office. And it purported to advise law enforcement of the client's right to marijuana as medically necessary. So the lawyer advised his clients, and of course the clients believed that they could possess, use, and grow, that will become important, cannabis due to medical necessity, and that they were protected by the affirmative defense of medical necessity. Lawyer didn't tell his clients that affirmative defenses only apply when you're arrested. They don't just apply in general. You don't need an affirmative defense if you have no reason to defend yourself. Several clients were arrested. I know you're shocked. Several clients were arrested and prosecuted, and the lawyer attempted to represent a couple of these clients. He was disqualified on a motion by the state attorney. They said he had a conflict of interest. So he refused to give the money back after the trial court ordered. He didn't comply, filed an untimely notice of appeal. The appeal was dismissed. He failed to respond to the order to show cause, and he failed to respond to show up at the order to show cause hearing. The order to show cause was granted, and a warrant was issued for the lawyer's arrest. So things at this point are not going very well for Ian. I will break the news to you. He never called me. I've never spoken to him. 3 other clients found out that the doctor who gave them the prescription was not licensed to practice medicine in Florida. The clients were never told this. This is a real case. Like, this really happened. So 2 clients were provided with a grow sign to be put outside their house saying, "We are cultivating marijuana." The police show up. I mean, seriously, the police show up. Somebody called 911. The clients contacted the lawyer to say if they needed to dismantle the growing operation. And they said they had nothing to worry about. Someone from his office was going to call the cops. Nobody ever called the cops. In February, a fully armed SWAT team. The clients did pay $799. SWAT team shows up, arrested, charged with manufacture, possession, trafficking in excess of 25 pounds. And the lawyer says they should file an IA report against the cops regarding the damage to their house and their belongings during the raid. Clients, everything was seized and detained for forfeiture. Clients hired new attorneys, got plea deals, 3 years probation, $15,000 fine, 100 hours of community service. This is where it gets bad. One client lost her nursing license of 25 years. The other lost his engineering job of 15 years. The landlord sued for damages and got a judgment in excess of $25,000 against these clients. So the judge took mercy on young Ian, gave him a 2-year suspension and payment of the bar's cost of $9,500. And then it went up to the Supreme Court because the Florida Bar appealed that decision. and they disbarred him. And you may be wondering why Ian got a 2-year suspension on what I think we will all agree is some egregious lawyering on behalf of his clients. And the reason was that Ian had been a member of the bar for less than 90 days. Any questions?